Morning, everybody. I am Scott Shealy. I am not Marin Boney, who was advertised as your moderator today. I'm a partner of Marin's. Marin was unable to make it. I'm a partner at Kirkland and Ellis after having spent more than 25 years in the Department of Justice. And I'm delighted to be here with this auspicious panel. This panel is about FTC rulemaking in the past. I'll ask the panelists to introduce themselves, and then Tom is going to start us off. But first, let me just assure everyone that there will be time at the end for questions, and I expect hopefully we'll get that kicked off with the panelists asking each other questions, and then there'll be time at the end for anyone out there in the audience who's interested in asking questions, and I'll definitely try to make time for that. So without further ado, if I could ask each of you to introduce yourselves, and then Tom, if you would get us kicked off.
Are these on, these mics? I guess they're on. Okay, Tom Merrill from Columbia Law School.
I'm Howard Beales. I'm an Emeritus Professor of Strategic Management and Public Policy at George Washington School of Business and a former Director of the Bureau of Consumer Protection at the FTC.
I'm Jeffrey Lubbers from Washington College of Law at American University, where I teach administrative law. Before that, I worked at the Administrative Conference of the U.S., ACUS, at the time when ACUS did a study of the FTC's Magnuson Moss rulemaking procedures.
Okay, so my assigned task, as I understand it, is to talk about ancient history, the FTC and its rulemaking authority, which I will interpret to mean history from roughly 1914 to 1973. Before I do that, I'll point out that I have an article coming out in the Administrative Law Review, probably in June, which is entitled Antitrust Rulemaking, the FTC's Delegation Deficit. And that article will cover issues like whether or not FTC rulemaking is a major question under the recent major questions decisions. My argument there is that it's uncertain, but that there are arguments to be made that it's not a major question because antitrust has been in the wheelhouse of the FTC since the beginning. So it's not a shift in the scope of its authority to regulate in that sense. And also that the argument about rulemaking authority based on Section 6G of the FTC Act has been around for at least 50 years, so it's not a dramatic, innovative, unprecedented legal argument as Chief Justice Roberts characterized the major questions in his majority opinion in West Virginia versus EPA. Anyway, and I also discussed whether or not how it will be decided under the Chevron doctrine. But my ultimate conclusion is that it should be decided as a matter of statutory interpretation. So let me focus on that. So I think the sort of shortcut to understanding the issues about FTC rulemaking up to 1973 would be simply to read two opinions. The district court opinion in the National Petroleum Refiners case decided by Judge Aubrey Robinson on the District Court of the District of Columbia in 1972. And the opinion of the Court of Appeals in the D.C. Circuit authored by Judge Skelly Wright in 1973. So those two opinions, I think, frame two different ways of approaching statutory interpretation. You can draw your own conclusions as to which approach to statutory interpretation is more congruent with the type of statutory interpretation that the U.S. Supreme Court has been engaged in recent years. And I think that gives you a good hint as to how this issue will ultimately be resolved by the federal courts if and when, I think it's almost certain that it will come before the federal courts on challenges to the FTC's authority in this matter. So if you look at Judge Aubrey Robinson's district court opinion, you'll find what I would characterize as a very conventional exercise in statutory interpretation, certainly conventional a la 1972. So he starts out by describing that the FTC Act has two primary sections in it. One, Section 5, is a grant of regulatory authority to the FTC to conduct adjudications to decide whether or not particular firms in particular industries are engaged in unfair competition. They issue complaints, they hold hearings. The hearings culminate in a cease and desist order. The cease and desist order then has to be taken either by the commission or by the party that's ordered to cease and desist to the U.S. Court of Appeals for enforcement. So the FTC has no autonomous authority to enforce its orders. The second section of consequences, Section 6, which authorizes the FTC to engage in investigations of corporations and their behavior and to issue reports embodying the information that they gather through those investigations for the use of Congress and for the use of the general public. So Section 6, the investigation authority, was the bill that came out of the House of Representatives, and Section 5 was the bill that came out of the Senate. The only reference to rulemaking, and this is all in Judge Aubrey Robin's opinion, the only reference to rulemaking is in Section 6G, which was part of the investigations authority, which authorized the FTC to classify corporations and to issue rules and regulations necessary to perform the functions under the Act. So Judge Robinson, Aubrey Robinson that is, made the point, which I think was sound statutory interpretation. If you look at the structure of the FTC Act, the regulatory authority says nothing about regulations, and the investigative authority is where you find this reference to regulations. And so it's not immediately obvious that there would be any authority to issue regulations under Section 6, the investigation provision, that would then carry over to Section 5 adjudications. Interestingly, he also made a reference to the fact that these two provisions, which were very different, had to be reconciled by a conference committee in the Congress. And the conference committee decided that they would just sort of paste these two things together. They would take the House provision on investigations and paste it together with the Senate provisions on adjudications. And Judge Aubrey Robinson even pointed out that under Thomas Jefferson's Manual of Legislative Procedure of 1834, that the House had followed consistently, at least since that time, the conference committee was not authorized to adopt a new provision that was not contained in either of the two houses' bills that went to the conference committee. So there was no provision in either of those bills for rulemaking in conjunction with the regulatory authority of the commission, which was to conduct these adjudications. And so that further reinforces the idea that Congress could not, if it was following the Jefferson's rules, could not have intended to authorize the commission to use regulations to augment its adjudication authority. I will point out that a noteworthy professor on statutory interpretation, Victoria Norse, has recently published a book, she's at Georgetown, arguing that the best kind of legislative history is the legislative history that follows the rules of Congress, including the rules about conference committees and what authority they have in terms of adopting provisions that neither house has adopted. The Aubrey Robinson opinion also mentioned some specific legislative history, as was conventional in the 1970s, of course. He mentioned that an amendment had been proposed in the House that would have granted some type of rulemaking authority to the FTC. That was rejected. He mentions, to my mind, quite tellingly, that Representative Covington, I assume he's of Covington and Burling fame, in describing the conference report to his colleagues in the House, stated that under the final bill proposed, the synthesis of the House and the Senate bills, the Commission will have no power to prescribe the method of competition to be used in the future. That's rulemaking. So the members of the House were specifically told that if they voted for the conference report, they would not be voting for any type of rulemaking authority in competition matters. So for the first 50 years or so of the FTC's existence, the FTC consistently interpreted its statutory authority to preclude any type of rulemaking the FTC did not specifically have authority over deceptive practices until the late 1930s, but throughout the period from 1914 even through the 1930s and up into the 1940s, the FTC consistently interpreted its statute as authorizing only adjudications, not rulemaking. Judge Robinson didn't mention this, but in the 1922 annual report of the FTC, we read the statement, this is from the Commission to the public, one of the most common mistakes is to suppose that the Commission can issue regulations unconnected to any proceeding before it. So the FTC was quite adamant about this in its public characterizations of its authority. Judge Robinson did go on to recite some more recent history and its possible implications. So the point about the FTC's understanding is there was a very strong canon of interpretation in the 1970s, still exists to this day, that contemporaneous interpretations of a statute by an agency of the statute that authorizes its authority that sets forth its authority are given extra weight, and long-standing interpretations of agencies are given extra weight. So the FTC's characterization of its authority was both contemporaneous and long-standing. So another interesting point about the understanding in this time has to do with arguably congressional ratification of this understanding of the FTC's authority. So throughout the early 1970s, Congress began enacting specific statutes that authorized the FTC to engage in rulemaking in prescribed areas. So there was something called the Wool Products Labeling Act, the Fur Products Labeling Act, the Flammable Fabrics Act, and the Fair Packaging and Labeling Act. Each of these gave the FTC authority to issue rules in these specific areas. And Judge Aubrey Robinson makes the point that if, in fact, the original act of 1914 gave the FTC rulemaking authority, there would be no need to pass these statutes. Congress, by passing these specific acts, clearly was ratifying the FTC's authority that it had no general or generic rulemaking authority, and that Congress had to pass specific grants of rulemaking authority in order to give it that authority. In the 1960s, the FTC, and even earlier than that, I think, the FTC did start experimenting with various types of innovative procedures. I think in large part this was a response to a hue and cry that came up during this time, most notably the Nader Commission report on the FTC, which chastised the FTC as a do-nothing agency that wasn't doing enough to protect consumers and so forth. In any event, the Commission had long engaged in something called trade practice conference rules and guides. These were really things that emerged out of various conferences that it held, a little bit like the codes of fair competition that the National Industrial Recovery Act had authorized during the Roosevelt New Deal. But those were widely understood not to be binding rules. They were not legislative rules that were binding as a matter of law, but were simply best practices kind of indications. But then in the late 1960s, the Commission began to adopt things called trade regulation rules, which were, I think, understood by the FTC to actually be substantive or legislative rules. They started out with minor things, sort of like what the commissioner was describing a little bit, with sort of minor regulations that no one would take offense at and so forth. But then they started building up to more significant rules. And Judge Aubrey Robinson pointed out that, at least with respect to the more prominent of these trade regulation rules, Congress had overridden each one of them. So Congress had passed, legislation that superseded rules about credit cards, rules about the shipment of unsolicited merchandise, and most prominently, a rule about labeling of cigarettes. Congress adopted legislation that essentially overrode or superseded each one of those rules that the Commission specifically understood to be regulations, and Judge Robinson points out that this further indicates that Congress seems to have, it's a weaker argument, but that Congress had ratified the FTC's original understanding. So Judge Robinson's conclusion is that the sum total of the FTC's arguments is a bootstrap operation designed to conclude that the FTC possesses power that it clearly does not have. So this decision goes up to the D.C. Circuit at the same time that Congress is considering legislation, the Magnuson-Moss Warranty FTC Improvement Act, that would have, according to the House at least, version of that, explicitly granted rulemaking authority to the FTC. But before the Congress could act, the D.C. Circuit weighed in with an opinion construing Section 6G as part of the investigation authority of the Commission to authorize legislative rulemaking in either antitrust or deceptive practices matters. The opinion really boils down to one argument. The argument is that it would improve the efficacy of the FTC if it were allowed to issue legislative regulations under the authority of 6G. So the court characterizes 6G as the plain meaning of 6G as including legislative rulemaking authority. That's not true. 6G is ambiguous as to what kind of rules Congress was authorizing the FTC to make. But the D.C. Circuit construes this to mean that it was facially broad enough to effectuate what it considered to be the purposes of the Federal Trade Commission Act. So the argument was, what are the purposes? According to the D.C. Circuit, the purposes were described as to create an expedited administrative enforcement of the national policy against monopolies and unfair business practices. So Congress had this very broad purpose, which was to, eliminate unfair competition and later deceptive practices, and rulemaking would be a good thing for the Commission to have in order to effectuate that very broad purpose. The key sentence reads as follows: in determining the legislative intent, our duty is to favor an interpretation which would render the statutory design effective in terms of the policies behind its enactment, and to avoid an interpretation which would make such policies more difficult of fulfillment, particularly when, as here, the interpretation is consistent with the plain meaning of the statute. So it's super broad, purposive interpretation. So those of you who have followed statutory interpretation in recent years, I leave it to you to decide which of these two opinions is more likely to be congruent with the way in which federal courts, as composed today, are likely to approach this issue. One that pays attention to the structure of the Act, to the history of its evolution, to the agency's contemporaneous and long-standing interpretation, and to Congress's various acts that ratify that early interpretation, or an interpretation that takes a cosmic conception of the purposes of the Act and decides what sort of regulatory tools would help the agency to fulfill those purposes. The only other thing I want to mention very quickly has to do with the Magnuson-Moss 1975 Act. The commissioner omitted some words from Section 6G was actually amended in 1975 by Congress when it passed the Magnuson-Moss Act. And they added the following words to Section 6G: except as provided in Section 57A A2 of this Act. Those words refer to provisions of Section 18 of the Magnuson-Moss Act, which granted rulemaking authority to the agency over deceptive practices. There were two sentences in the cross-reference provision. One said that the rulemaking grant over deceptive practice was going to be the exclusive authority of the FTC in deceptive practices matters. The second sentence basically said, well, I can quote it to you: the preceding sentence shall not affect any authority of the Commission to prescribe rules, including interpretive rules and general statements of policy with respect to unfair methods of competition in or affecting commerce. So the second sentence is basically a sentence that says we're not saying anything about antitrust rulemaking, we're just going to leave things as they are. So the big question, I think, that will come up in the litigation over the FTC's rulemaking authority over competition matters is whether or not the 75 Act ratified the National Petroleum Refiners' decision of the D.C. Circuit, or whether it ratified whatever the Act would be correctly construed to include as a matter of original understanding. And I leave it to you as to which prediction is more likely to be true. Thanks.
Thank you, Tom. Howard, do you think you can pick up off of cosmic purposes of the Act and let us know what comes next?
There was an attempt to pursue cosmic purposes in a lot of the 1960s and 70s rulemaking. I just want to note one thing about 6G rules that were upheld in Octane. It was a very different kind of rule than what we think of as FTC rules today, because it essentially it could only be enforced through an administrative action where the only consequence of the commission finding a violation of its rule was a cease and desist order. That's not the way consumer protection rules work, where there's substantial civil and equitable remedies for violations. And there's also was a safety valve in those rules. The rules themselves said that that any alleged violator would have a hearing on whether the rule should really apply to them. And that safety valve was specifically cited in the D.C. Circuit opinion in upholding the rule. So it's closer to a modern FTC guide than it is to a rule, unless the rule is a really simple one. The one rule I want to focus on from the early days is the 1964 cigarette rule, because that set forth a test for unfairness as an unfair practice that said a practice was unfair if it was immoral, unscrupulous, unethical, or oppressive, if it caused substantial injury, or if it violated public policy. The commission didn't do much with that after the cigarette rule until 1972, when the Supreme Court cited that unfairness test in dicta in the S&H case, and seemed to bless that test for whether a practice was unfair. That led the FTC to create an office to explore the limits of unfairness. That considered all sorts of possibilities as to what they might do with rules based on this expansive notion of unfair practices that included anything that the commissioners thought was unscrupulous, at least potentially. My favorite, which is still a joke among longtime FTC staffers, was the unfair distribution of wealth rule, which may yet return. Congress was concerned about the use of rulemaking in large part because of the FTC's broad discretion. Unfair and deceptive practices was never a precisely defined set of terms. The agency has a lot of discretion. The way Congress dealt with that discretion was procedurally. It codified hybrid rulemaking regarding unfair and deceptive practices in Magnuson-Moss. Those procedural requirements were intended to curb discretion, to enhance the role of reasoned decision-making in the rulemaking process, and to expand the opportunities for public input in rules themselves. The result of S&H and the statutory authority was a rulemaking binge. In the first year after the statute, the Commission issued 16 rulemaking proposals affecting broad segments of the economy and often radically restructuring or proposing to radically restructure industries. Only 5 of those rules survived, and the survivors were shadows of the original proposals. They were all scaled back considerably, and a number of them actually had a competition rationale. The political reaction to the rulemaking binge was devastating to the agency. The binge culminated in one sense, although it's after the binge itself, in the children's advertising rulemaking proposed in 1978. That led the Washington Post to call the FTC the national nanny, and it led, for the first time in American history, Congress cutting off funding for an agency over a policy dispute. I was there, and we were told we could only do activities engaged in orderly shutdown, so you could pack your boxes, but that was about it. The failure of the binge has really given rise to the myth that Magnuson-Moss procedures were cumbersome and unworkable. But the rules failed because they were bad rules. They lacked clear theories of why the conduct they were challenging was illegal. They lacked substantive theories of why the conduct was occurring or why the remedy would fix the problem. And they lacked systematic evidence about either the problem or the remedy. rules that had clear theories and systematic evidence, like a rule that would have preempted state bans on eyeglass advertising, or a rule that required labeling the R value of home insulation. Those rules were completed quickly. Each of those rules was completed in less than 2 years. The average is probably closer to 10 for the other rules out of the binge. But what happened was the process did its job. It prevented a lot of really bad ideas from becoming law. It wasn't that the process itself caused the failure. The proposals had the seeds of their failure built into them, and the process revealed those problems. But that's what a process ought to do. In July of 2021, the FTC adopted revisions to its rulemaking procedures. They adopted it 3-2. There was no public input in contrast to prior implementing rules for the rulemaking process. And there was no input from most of the career staff at the agency. The rationale was expediency. They were allegedly removing onerous procedures adopted in the Reagan administration in efforts to curtail rulemaking. There's nothing in the proposal for the changes about the effects on the quality of the Commission's ultimate decision. That was not a factor that was considered. There's just two problems with the reverse the Reagan administration story. One is the rules they revised were all in place before anybody arrived from the Reagan administration. This was the Carter administration's rules. And in every rulemaking after that initial binge, the Commission has used some sort of alternative procedure. It modified the rules as they were published in order to structure the process a little bit differently. But the changes that were made in 2021 together are a recipe for greater political control, which Commissioner Wilson talked about, and less public input. And I want to talk about really 4 key changes just briefly. One is less explanation. The original 1975 statute required the Commission to explain the reasons for a proposed rule with particularity. In 1980, the 1980 Improvements Act, Congress wanted 2 more things explained with particularity: the text of the rule and any alternatives under consideration. And so it added that phrase between with particularity and the reasons. Okay, the 2021 rules read particularity out of the requirement for the explanation of the reasons. Despite the requirement for particularity, one of the big problems with the 1970s rulemakings in the binge was the lack of sufficient explanation of what the Commission thought it was doing and why it thought it was illegal. The problem was too little explanation, not too much explanation. But what the Commission has said is, well, we don't need to explain ourselves with particularity. I think that's a requirement that's clearly inconsistent with the statute, but hopefully they will, in fact, explain themselves when they issue notices of proposed rulemaking. The second change was the role of the presiding officer. One of the things that happened in the 1970s rulemakings, in part because they dragged on for a long time, was that the staff working on those matters developed a real commitment to the proposal. They were advocates for the proposal. Whether the record supported it or not, they were going to make the best argument they could for the rulemaking proposal. By 1980, there was a consensus at the Commission that one way to check that tendency of the staff to defend what they'd started with was to rely more on the presiding officer. And there was a policy review session that decided to do that, there were not subsequent rules where it was actually implemented because there weren't subsequent rules. But there was a consensus that the presiding officer's role was important and important as a check on the staff. The 1980 Improvements Act essentially codified that. It required an independent presiding officer who reports only to the chief presiding officer. But now the chief presiding officer under the 2021 changes is the chair. So this is more political control for the process and less independence for the presiding officer. The 1980 Improvements Act also requires that the presiding officer make a recommended decision. It's a recommended decision about the rule, if you read the statute, and that recommended decision is to be based upon the findings and conclusions of such officer as to all relevant and material evidence. The presiding officer is supposed to look at the whole rulemaking record and say, here's what I think you guys ought to do, as an independent voice. The rule changes that the Commission adopted in 2021 restrict the recommended decision to the designated issues that the Commission itself identifies. So the rule now says the presiding officer should answer the Commission's questions and no others, without regard to any evidence that may be uncontested, even if it's crucial to the significance to the decision about the rule. The third change has to do with designated issues. Now, under Section 18, if there is a disputed issue of material fact necessary to resolve, that's a designated issue. Okay, and a designated issue triggers a statutory right to oral presentations and cross-examination and rebuttal submissions. The original idea was designated issues would work to narrow the issues that were in dispute and narrow the focus of hearings, and unfortunately that never happened. Presiding officers, instead of trying to figure out what issues were really in dispute, and this is partly because the explanations were unclear as to what facts really mattered in the rulemaking proposal, presiding officers traded designation of issues for time. And instead of trying to limit the substance of presentations and cross-examination, they just limited the time. All right, ask about anything, cross-examine about anything, but don't take too long. And so they never narrowed the issues. They never worked the way they were supposed to. Under the new rules, it's the Commission who's going to designate the issues. And they're going to designate the issues in the initial notice of proposed rulemaking before there's any opportunity for public comment on the specifics of the rule. But it's comments that have often been crucial in identifying what are the real issues in rulemaking. In the business opportunity rule, for example, in 2006, it was public comments that identified the key issue of how should the rule apply to multi-level marketing companies. The staff hadn't intended to regulate multi-level marketing companies. It didn't see that that was an issue that was crucial. But comments made clear that that was an issue and a real issue. The staff ended up proposing a new rule that tried to avoid the problem. Commission designation is also likely to slow the process, not speed it up, despite the rationale for expediency. The one time when the Commission reserved for itself the ability to designate the issues was the children's advertising rulemaking. The presiding officer's recommendation for 3 designated issues went to the Commission. The Commission never decided. So how that's going to make things faster is not so clear. Final change I want to mention is the staff report, which Commissioner Wilson also mentioned. Now, there's going to be a staff report because the staff is going to have to analyze the record and make a recommendation to the Commission. It's just not going to be public. So we're not saving any time in preparing that report because the staff's going to have to do it anyway. We're just not going to let the public see it. Okay, and the staff report under the old rules was out for public comment along with the presiding officer's report. That comment was important because staff recommendations were often substantially different from the initial rule and may or may not have fixed the problem. And public comment can help you to tell you that. The Commission is clearly relying more on rulemaking. It has yet to issue any NPRMs under Section 18. Several ANPRMs are out there, which is the first step of the process. So it has yet to actually adopt a process for how hearings and the like will actually work. But the NPRMs that are out there are under other authorities and not Section 18 rulemakings. It'll be interesting to see how it works.
Thanks a lot, Howard. So, Jeff, we've got cosmic purposes of the act and national nanny. Let's see what you can.
Okay. Well, thank you. It's a real honor to be on this panel with Professor Merrill, who is one of the leading scholars in the country, especially on matters of statutory interpretation, and Howard, who probably knows more about the FTC than anybody who's not named Bill Kovacic. Tom and I were on a panel at George Mason back in October, and since that panel, the FTC has issued its first unfair method of competition, or UMC, proposed rule. In the 6 weeks since it was issued, it's already drawn 13,000 public comments, I noticed, on regulations.gov. And I don't feel like I can really second guess Tom's and Commissioner Wilson's expert predictions on what might happen with the inevitable court challenge to whatever the FTC promulgates as its final rule. And remember, it's just a proposed rule at this point. But I do think there's a significant possibility that the Supreme Court would not follow national petroleum refiners. They might invoke the major questions doctrine, which I'll call the MQD. And if push came to shove, might even question Humphrey's executor, although they probably would not have to go there. But when Aaron asked me to be on this panel, I think he expected me to talk a little bit about the judicial review hurdles and also the paper that I wrote for GW Law Review back in 2015, in which I criticized what I called the mossified procedures that the FTC was stuck with using for its rulemaking. And by that I meant the formalistic procedures that were added to the Act in 1975 and 1980, which the FTC has scrupulously avoided in the non-compete rulemaking on the ground that those procedures don't apply to UMC rulemaking, unfair methods of competition rulemaking. So I want to focus first on the major questions doctrine hurdle, which I know Tom is writing about, but it was only, of course, anointed as a doctrine in the recent West Virginia versus EPA case last term, and it's rapidly attained the status of a powerful tool for judges who are deeply skeptical of administrative regulation. What started off in the MCI case in 1994 and the Brown and Williamson tobacco case in 2000 as one of many considerations to be used in statutory interpretation and in undertaking the Chevron two-step analysis has, during the pandemic, morphed into an Omicron-like variant that has the potential to swallow up not only the Chevron doctrine itself, but any effort by an agency to use existing statutory authority to do much of anything of significance. It's also, interestingly, obviated the need for judges to invoke the much blunter tool of the non-delegation doctrine. As Mila Sahoni pointed out in her excellent article in the Harvard Law Review about the quartet of recent MQD cases, the non-delegation doctrine has a lot of pitfalls, and the new version of MQD enables courts to skirt those pitfalls. It gives courts a basis for invalidating the most important exercises of delegated authority without requiring a finding that the entire statute is an unconstitutional delegation. All they have to do is find that the action is a major question and then find a lack of a clear statement from Congress authorizing the action. But the problem, of course, is the MQD's indeterminacy. We really don't know what major means in this context. Some of the decisions limit the doctrine to questions of, quote, vast economic and political significance, while other formulations seem to leave the word vast out. And Justice Gorsuch has turned the and into an or in his concurrence, meaning economic or political significance. Some have even suggested that we should use the definition of major used by OMB in its review of regulations, as ratified by the Congressional Review Act, meaning a regulatory action with an impact of over $100 million on the economy. But that benchmark was set by Jimmy Carter in Executive Order 12044 in 1978. In today's dollars, that would be $459 million. But of course, the executive orders haven't been indexed for inflation. So would any rule that has over $100 million of impact thus be within the major questions doctrine? I think that would be extremely debilitating to health, safety, and environmental and consumer regulation in our country. And the clear statement part of the test also suffers from the indeterminacy of the word clear, not to mention the dysfunction of Congress that prevents it from passing most bills that are not part of the budget reconciliation process. So when we think about applying the MQD to FTC rulemaking, wouldn't most trade regulation rules, the funeral home rule, the home installation rule, the vocational schools rule, wouldn't all of those be potentially considered a major rule? And if they are, would the Magnuson-Moss Act be a clear enough statement of authorization? We don't know. And with respect to potential UMC rules, the only authorization is Section 6G. And as Tom suggests, that may not be a clear enough statement. Some have even contended that the mere choice to use rulemaking over case-by-case adjudication in this area constitutes a major question, even though most regulatory agencies use both rulemaking and adjudication to make policy, and the Supreme Court has repeatedly emphasized that this is the agency's choice to make. Now, of course, the agency must have delegated authority to issue legislative rules in the first place. Most agencies do, most regulatory agencies do. And the Supreme Court, in numerous cases, in the past at least, have interpreted general delegations of rulemaking authority, like that in Section 6G, to encompass the power to make binding regulations. As recently as 2011, in Mayo Foundation for Medical Education and Research versus U.S., the Supreme Court stated that the question of whether Congress, quote, delegated authority to the agency generally to make rules carrying the force of law does not turn on whether Congress's delegation of authority was general or specific. Now, this is consistent with National Petroleum, and I certainly found Tom's remarks to be persuasive in the other direction. And maybe the Supreme Court will agree with that, with his qualms there. But a lot of courts' decisions and others have recognized the value of rulemaking. And don't forget, administrative adjudication is also under attack these days. The independence of ALJs is under constitutional challenge, and the Fifth Circuit in the Jarkissi case has ruled that the SEC's administrative adjudication of fraud cases violates the Seventh Amendment right to a jury trial because those types of fraud cases were common law cases dating back to Old England. Well, this theory, if it was accepted by the Supreme Court, could certainly hamstring the FTC's enforcement program. All right, well, let me turn to the Magnuson-Moss procedures now. We know that in 1975, Congress added Section 18 to ratify the agency's power to issue trade regulation rules, but added a bunch of additional procedures, I counted 15, to the basic APA notice and comment rulemaking process. And they added even more in 1980. So some have pointed to Section 18 as a reaffirmation of the D.C. Circuit's National Petroleum decision that the FTC did have rulemaking authority under Section 6G. Others have suggested that it was a reaction to the decision intended to constrain the Commission's rulemaking authority. Both things could be true. But as Tom said, Section 18 also disclaimed any effect on any authority of the Commission to prescribe rules with respect to UMC. In my article, I documented the long delays in FTC rulemaking that occurred after the Magnuson-Moss procedures kicked in, especially after the 1980 amendments, compared to the pre-Magnuson-Moss rulemakings, or to the dozen or so rules that have been issued by the FTC by special permission from Congress under regular APA procedures. So the delays were so lengthy that the FTC basically gave up on issuing new rules under Section 18 after 1980. Now there are a few that have been issued under the new administration as ANPRMs. There may have been some other contributing factors to that, and Howard's identified a few. But the fact remains that for 40 years, FTC rulemaking under Magnuson-Moss was a non-starter. So just to summarize my findings in terms of timeframes in that article, the FTC was able to issue trade regulation rules before Magnuson-Moss in about 3 years, 2.98 years to be exact. After Mag-Moss was enacted, it took the agency 5.72 years to issue the 7 rules it managed to issue using those formalized procedures. And one of those was overturned. I guess the other 6 were not. And the agency also had terminated some other rulemakings that were in progress. And it was a little hard to figure out exactly when the termination date was. But, I took the last entry in the Federal Register for those rules, and the average time between NPRM or ANPRM and the beginning and the end was over 8 2/3 years for those. But I think one of the more damning parts of it is that the agency also has to use Mag-Moss for amendments of existing rules. And those took 5.26 years just to issue the amendments on the average. But when the FTC was able to use the 8 regular APA procedures to do the dozen rules that it issued between 1993 and 2009 at least, it only took 287 days on the average. Even though the FTC adds some additional procedures to the APA voluntarily, they've added additional opportunities for public input. They've used ANPRMs and public workshops and forums in some of those rules too. So now they're gearing up for another try. And they've streamlined some of the things that Howard has just criticized. They've tried to streamline those procedures. But streamlining is not only controversial, it can only go so far. So that's why I've advocated for legislation allowing the FTC to use regular APA rulemaking procedures, as most agencies do, for its rulemaking. And Congress almost made that change in Dodd-Frank. One of the houses passed that change, the other house didn't, and it didn't survive in the conference committee. And by the way, I think Kirkland and Ellis had something to do with all that. Now, my figures are admittedly a bit dated, but I think the basic point is still true. Magnuson-Moss rulemaking takes an inordinately long time, longer than the average term of an FTC commissioner. And it is therefore hard to blame the FTC for seeking to use standard APA procedures for its unfair methods of competition rulemaking. Its choice of the non-compete clause issue as its trial balloon is the one that Professor Pierce suggested in an article that made the most sense of all the possibilities. So we'll see what the final rule ends up saying. It probably will get narrowed, and we'll see how the FTC is able to navigate the increasingly dangerous shoals of judicial review. Thank you.
Thanks very much, Jeff. And you didn't disappoint with your own catchphrase of Omicron variants of administrative procedure. So we have about 10 minutes left. Let me start off by asking our panelists if any of you have questions for one another or observations based on each other's comments. I guess it looks like everybody might be interested, so why don't we start with Tom and work our way down?
First of all, I'm just interested in being educated a little bit more about the FTC rulemaking. So I have spent some time lately looking at the legislative history of the 75 Act, which was clearly motivated. I think there was a fashion at that time for what was called hybrid rulemaking.
Yes.
When rulemaking touched upon difficult questions of fact, and I think maybe that was sort of like adjudicative fact rather than legislative fact, but maybe both, that it would be useful to have something like oral argument and cross-examination in order to challenge the agency's assumptions about the facts. So those two things were written into the 75 Act, as was the substantial evidence standard of review for the Court of Appeals, which presupposes that, they're going to be reviewing questions of fact with somewhat more closely than under an arbitrary and capricious standard. My assumption has been that all these other procedural requirements, like, having a ALJ preside over the rulemaking, why are they called presiding officers now? Is this the new fashion, or is this statutory change?
It didn't have to be an ALJ.
It didn't, and it wasn't. There's actually the only rulemaking in which an ALJ presided, the only one is children's advertising. And it was a specific choice by the commission that they wanted an ALJ to do it. The presiding officers in most, and I think actually that was part of the problem in the 70s rulemaking, most of them, the presiding officer was somebody off the staff.
I see.
And often on the staff of the rulemaking, the special division for rulemaking within the agency. And they didn't know how to run a hearing. That wasn't their expertise. ALJs are good at that. They know how to do that. And the children's advertising procedure, progressed expeditiously until it got back to the commission.
Right. Well, Jeff, you said that 15 procedures were added by the 75 Act, but the only ones that I'm aware of are the cross-examination, right of rebuttal, and substantial evidence review. And my impression was that all these other requirements were added by the 1980 Act, but maybe I'm.
I think it's a mixture. I mean, I didn't parse out which ones were added by which act, but when I came up with my list of 15, they're all listed in the statute and in my article. But mandatory ANPRM is one of them. And most agencies don't have to do that.
That's the 80 Improvements Act.
Mandatory oral hearings. I mean, you're right that there was sort of a hybrid rulemaking fad at the time during that period, and OSHA has to do it, and Consumer Product Safety Commission, and there were some procedures added just to a few EPA rulemakings.
But then you get this wave of law review commentary about ossification.
Yeah.
Rulemaking is
Right.
slowing down the regulatory process, and
Congress hasn't done it since.
And so the fad ends, right?
Yes.
So did the Vermont Yankee contribute to the fad ending, or was that just sort of orthogonal?
That was 1978, and that was basically, I think the
courts don't have
Florida
authority.
East Coast case, I think, was the case that kind of helped contribute too, because that was a case where the court really limited, and Aaron's an expert on this, he wrote an article, limited the reading of statutes that might require formal rulemaking under the APA. Trial-type rulemaking under the APA, the Supreme Court said it had to have the magic words on the record in the statute. And so the Supreme Court sort of realized, I think, that formal rulemaking wasn't a good practice for rulemaking. It was after that famous peanut butter, the peanut butter
The
rule
FDA
and
case, yeah, right,
so
yeah.
on. So an administrative conference came out with some recommendations saying that Congress should normally not use procedures in addition to notice and comment and rulemaking. So the FTC and OSHA and a few other agencies are sort of outliers in the overall rulemaking picture. Now, maybe I'm sure that some good things come out of these hearings, but, rulemaking is supposed to not be an adjudicative procedure. Adjudicative facts are not usually involved in rulemaking. It's questions of legislative fact.
One thing that strikes me quite clearly, though, is that if Congress in 1975 was intending to ratify national petroleum refiners, they almost, and given that Congress was alarmed by the bare bones nature of 553 rulemaking as applied to deceptive practices, it's almost QED that if they thought they were ratifying rulemaking for antitrust, they would have mandated hybrid procedures for antitrust.
So why didn't they? Why did they have to put that disclaimer?
Because they were not ratifying this
But
aspect.
why did they put that disclaimer in there then?
Well,
It was not a disclaimer. The disclaimer says we're not touching any authority
Yeah.
that they might have. So.
and my understanding was the industry liked these guides that were issued under 6G before that you mentioned, that was a useful practice, and they were afraid that that would be considered a rule and didn't want it to be considered a rule subject to Section 18 requirements. I mean, that's the story I've heard. I don't know.
I thought that the merger guidelines somebody must have pointed out that the merger guidelines, which were adopted initially in '68, they were a policy statement. They were not a legislative rule, but they were very important to the FTC, and so you had to grandfather those without question. And the savings clause specifically mentions policy statements. Yeah.
So let me just pause the very interesting discussion. I'm sorry, I hesitate to do it, but I do want to give everyone in the audience an opportunity to ask a question before I think we'll probably continue where we left off. I know Howard, I think, had a question. Anyone in the audience want to ask anything? Okay. Can I pick up with what your observation or question?
Sure. I have a comment for Jeff and a question for Tom. The comment is there's no question that the Magnuson-Moss rulemaking took a long time. I don't question those statistics at all. I don't think it was the procedures that made them take a long time. I think it was inattention that made them take a long time, and lack of clarity about what they were really trying to do. As I mentioned, the two binge rules with clear theories and clear evidence went quite expeditiously. The other thing that went quite expeditiously was in the 90s, in the Potofsky administration, the commission repealed 6 of the early Mag-Moss rules in a proceeding that for most of them was less than 6 months and for all of them was less than a year. The procedural requirements didn't get in the way, although those repeals were essentially uncontroversial, and that the process can obviously work quickly there. But I think the key is clarity about what facts matter, and then focus the rulemaking on those facts. I do think cross-examination is potentially useful in some of these. In this earnings claim ANPR, for example, there is already in the advance notice stage, there are dueling surveys about how consumers understand these claims. And cross-examination is potentially a very useful way to explore that. That's exactly what you do in an adjudication alleging somebody's advertising was deceptive with conflicting surveys, and cross-examination is a reasonable way to do that. My question for Tom is, Section 18 and the part with the savings clause seems quite clear that if it's an unfair act or practice, Section 18 is the exclusive way to go. Mm-hmm. What about a practice that is both an unfair method and an unfair act or practice? How does Section 18 and the savings clause affect that?
I have no idea, but I would interpret the statute to say that if you're invoking the authority over deceptive practices, either in whole or in part, then the exclusive method is the Magnuson-Moss rulemaking process. I did look up, as part of my, efforts to write this paper, the octane rule as it exists today.
Yeah.
Its justification in the CFR is that it's based on deceptive practices. Now, they didn't have to do Magnuson-Moss in order to do the octane rule, because there's another provision of the 75 Act that grandfathers all the existing rules that were promulgated under 6G before the 75 Act was passed. But now they've sort of subtly, the original rationale in the Federal Register was it was a combination of competition and deceptive practices. They now in the CFR have changed it somewhere along the line to be just deceptive.
What if they amended it?
Well, actually, they've amended it several times, but it also got moved out of trade regulation rules because there's a special statute that Congress passed on octane disclosure, and so now it's a rule implementing a special statute,
okay, so maybe that
rather than
it,
a
right.
trade regulation
Right.
rule.
Maybe that explains it anyway. Just briefly on major questions, I think this FTC thing is going to be really, really interesting because people are obviously going to challenge it as being a major question. There's, Eugene Scalia has already written an editorial in the Wall Street Journal saying this is a major question, so it has to be governed by that doctrine. It's interesting to me that if you just focused on the regulation, the proposed regulation on non-competes, then it satisfies this, large numbers of people, large number of dollars criterion for being a major question. But as you pointed out, Jeff, practically every major antitrust case would satisfy that, and even a deceptive practices rule regulation would satisfy that. So I don't think that can be right. The reason why I don't like the major questions doctrine, I think it was a huge mistake, but I think it's doubtful for a couple of reasons. One is that, the FTC has adjudicated antitrust cases since 1914. This is in their wheelhouse. And so this is not the FTC reaching out to regulate some new thing like, public health when they're really a labor organization or something like that. And secondly, this argument about 6G has been around since 1969. So it's not like Roberts emphasizes the unheralded, unprecedented, novel nature of all these agency rules that are major questions. Whatever else you can say about this is not novel and unheralded. It's been around for over 50 years. And so,
and other agencies have issued antitrust regulations, right? CAB did, I think, and
oh, really? Yeah.
I think so. And
Under
FCC
under general regulatory rules and regulations.
well, I'm not sure, but I mean,
Yeah, right.
Well, we are exceeding our time, so.
I'm sorry.
No, it's okay. Really interesting conversation. Thank you very much, Tom, Howard, Jeff. Really appreciate it.
Thank you. Yeah.